All right, welcome back. And as I said before, we're going to get another legal opinion on this. And now being joined on the program by GT Ogunye, who is a legal practitioner. Mr. Ogunye, thank you very much for coming on the program.
Thanks for inviting me.
In the past, you maintained that the CJN, going by the law and pronouncement of the court, ought not to have been tried by the Code of Conduct Tribunal, that, the NJC should have taking action against him before the Code of Conduct Tribunal, or before he's arraigned before any court of law at all. Now, you've seen the judgment of the Code of Conduct Tribunal saying that it tried him as a public officer, not as a judicial officer. And the Code of Conduct Tribunal clearly tried to distinguish between his case and the case of Justice Unguta that had earlier come before this Code of Conduct Tribunal, and that the Code of Conduct Tribunal had to dismiss, citing, of course, the case of Nganjiwa versus the Federal Republic of Nigeria. So what's your take on this now? Has your position actually evolved?
My position has not evolved, it's not changed. My position has not changed on the subject. In the course of the week, the High Court in Lagos, Koram Oshodi, Justice Oshodi, struck out a case that was brought on similar grounds. The case of Nganjiwa and the Federal Republic of Nigeria admits of no exception once you are a judicial officer.
Irrespective of the fact that you're also a public officer.
You ought not to be. The intention of that judgment, I insist, is to insulate judicial officers from the possibility of a spectacle of having a serving judicial officers being arraigned before any court of law or a tribunal.
Which, of course, it would be an embarrassment and a disgrace.
And my position has been and remains that because of the principle of precedent and stare decisis, until that decision is set aside by the court, the Supreme Court, that it will not be appropriate for us to pretend that that decision does not exist. Now that this decision has come by the Code of Conduct Tribunal and an appeal has been lodged, I think that a party who felt dissatisfied with that verdict, and obviously the CJN, former CJN, felt dissatisfied, will test this issue in the Court of Appeal and perhaps later at the Supreme Court. So my position has not changed. My view is that what the federal government of Nigeria did was to force the issues. Justice Onnoghen, it was desirable that you leave office, you will not leave willingly. So we'll force the issues and then we'll make you leave. The provisions of the constitutions are there for everybody to see. The intendment of the lawgiver, talking about Section 292 of the Constitution, which provides security of tenure for judicial officers, is to ensure that certain judicial officers are not removed from the bench without passing through certain procedures. As a matter of fact, if the federal government and the president in particular had accepted the recommendation of the National Judicial Council.
But that recommendation, it would appear, came very, very late in the day.
No, what I'm saying is that it came, at any rate, before this judgment.
And I was just going to ask you.
So it came before this judgment.
Yeah, but
so the point I'm making is that if the federal government were to accept that recommendation...
And probably withdraw the case before...
No, if the federal government were to accept that recommendation, the federal government would still run into some trouble. And I think that they appreciate this. What's the trouble here?
Yeah.
Under the Constitution, regarding the office of the CJN, the president can't accept a recommendation of the NJC to remove a CJN or compulsorily retire him from office. Because Section 292 says that those judicial officers shall not be removed before retirement, before attaining retirement age.
In that case, the NJC has
just
no
a
power
minute,
over the...
just a minute, please. If the federal government were to accept that recommendation, they will still run into the trouble of how do we accept this recommendation without going to the Senate for a concurring two-third majority votes. You see, the Constitution it can appear complex.
Okay, now you're saying even though the content of the recommendation has not been made public, but if, as we are hearing, as we're hearing, of course, if what we're hearing is correct, that the NJC actually recommended the compulsory retirement of the former CJ, and for the federal government to accept that,
the president acting alone cannot accept that recommendation
without
the Senate approving of it, because the tenure is secure. The idea and the ideal are to ensure that there is independence of the judiciary, and that judicial officers can't just be removed, based on the whims and caprices
of the president,
of those who are exercising executive authority. That's the idea. Now, can this be abused by judicial officers themselves? Of course, yes. And we saw that kind of abuse when, the NJC didn't even meet on Justice Onnoghen's case until a special requisition by some of the members who felt embarrassed. There was supposed to be a meeting on January 15th, which was postponed by him because he was the chairman. He alone appoints at least 14 members of a 21 or a 22 member NJC. So you can imagine the kind of the enormous authority that he wields over that. Yes, it can be abused, but the idea is to ensure that you have that security of tenure. And so you now have these three situations. First,
he resigned.
No, that came second.
That came second, yes.
Which
you have the recommendation of the NJC.
There was a recommendation of the agency.
And then he resigned.
The executive president has not accepted one way or the other. I have opined that you can't accept it alone without working. So as that was being grappled with, what was government going to do? He resigned. And of course, since it is not by conscription, you can't force him to continue to work any longer because he's resigned. But even that one is still subject to controversy because people are saying that that resignation had not been accepted by the president and all that, and we didn't know whether he actually had to resign, by giving a letter of resignation to the president. But in the face of all that, we then have this conviction. So you now have three situations. Is it to accept the recommendation of compulsory retirement
by the NJC?
By the NJC.
Or to accept his resignation?
Or to accept his resignation and say he's resigned anyway. Or to say, now it is the rule of law we're going to follow, the court has ruled. Or the Code of Conduct Tribunal has ruled. And regardless of the fact that you have the right of appeal, that still remains the verdict. And of course, the NJC tactically recognized that also in its recommendation when we were told by the spokesman who said, look, we didn't dabble into the issue of the Code of Conduct. Because that's sub judice. So we didn't dabble into it, thereby providing a leeway, so to speak, for the NJC, for the Code of Conduct Tribunal to consummate whatever it was doing. So we had that kind of three situations. But what is important is that whatever will be decided at the end of the day on this matter, the former CJN, and I'm using former advisor because he's resigned from office.
He did confirm. I mean, his lawyers did
confirm that he's resigned. The former CJN has left the Supreme Court for good. And of course, once you leave that office, you will have to, perforce, leave or relinquish the office of the chairman of the NJC, the chairman of the National Judicial Institute, the chairman of the Federal Judicial Service Commission, because he's the chairman of all these bodies. So he's left, and so we can now be talking about a post-Onnoghen era, at the Supreme Court.
But very quickly now, because we're actually out of time.
Yeah.
Going forward, what do you think needs to be done? What reforms would you say need to take place now so that we don't end up in a situation like this in the future?
This has been said over and over again, we need to rethink the composition and the constitution of the NJC. The Federal Judicial Service Commission and all such bodies, particularly the disciplinary process. I have argued before now that the decision of Nganjwa and the FRN is problematic. That's not the law. Judges had no such judicial immunity against criminal prosecution while they are serving. Legislators, including their principal officers, have no such judicial legislative immunity. You can't extend it to cover that. Of course, there's a concept of judicial immunity. There's a concept of legislative immunity. But you can't then extend it beyond its confines and all that. And so, now that we having an attempt to clothe judicial officers with that kind of immunity, thereby compelling a restive executive to then go through the route of the code of conduct, which if it becomes a precedent, because it's already a precedent now, if it is sustained up the ladder, will then be a recourse to say, since you will not allow us have it this way, since your NJC will not sit, since you are the Lord unto yourself and the NJC will always go through this route, which is also fraught with danger. Absolutely. Because it may then get to a stage that the executive may want any judicial officer out and say, don't worry, we'll go to the CCT, you are not controlling there, and then we'll obtain an ex parte order against you first, and then we will then remove you. So we need to reform the system. And I hope that after this whole saga, the executive, I've called for it before and I'm calling for it again, should have to empanel with the cooperation of the NJC. It doesn't appear that the NJC can self-reform. It doesn't appear that the politics of gallantry, the politics of recognition, the politics of getting opportunities and privileges in the NBA will make the NBA to push for this kind of reform. So I think that the executive, in cooperation with all this body, should have to set up a grand commission to think through the issue of reforms in the judiciary, because these are very critical. And I don't want it to be politicized. So I just feel strongly that we need such. Since we had a short panel, which was talking about corruption and all that, yes, that was good. We would not have that kind of grand commission. And this one would not be fixated on corruption alone. It will be looking at how to ensure that the judiciary plays the critical role it ought to play as a stabilizer and a purifier of our democratic process. Because if a body that is set to purify in self-needs purification, you know that leaves much to be desired. We need that grand commission moving forward.
Absolutely, no doubt. And it just doesn't make sense that, the Chief Justice of the country would be responsible for the appointment of about 90% of the members of the NJC.
It doesn't make any sense.
It just doesn't make any sense at all. Thank you very much for coming on the program. We're going to take a short break now, and when we come back, we'll be discussing labor matters. As you're aware, the federal government has, of course, approved the 30,000 minimum wage. Of course, workers will definitely be happy across the country, and it comes just days before May Day, which is Workers' Day, May the 1st. So that's what we'll be talking about next. Stay with us. On Deji 360, we don't just ask the questions. What is wrong with amending the Constitution the way the National Assembly members have been doing it? We seek answers.
Constitution is constituent.
Our problem is not lack of laws. Our problem is lack of the willpower to implement our laws.
Answers that provide clarity.
While we negotiate, we should try to make it a point that the girls must be complete.
The clarity you need to make informed judgment so that you can make the right decision and take action. People are saying it is you politicians that are responsible for this, that you are the reason why this is happening.
All these dollars that call themselves governors in this country?
I wish we had people like Tony at the National Assembly.
God forbid that I go to join that band.
Deji 360, providing clarity to issues.